Hi, I'm Shashank Bhargava, and you're listening to Three Things, the Indian Express news show. For nearly 4 years, the Personal Data Protection Bill was being worked on. The idea behind the bill had been to protect the personal data of individuals and establish a data protection authority that would hold companies, governments, and individuals responsible if they violated someone's privacy and used or collected data without their consent. The bill was being looked at by a Joint Parliamentary Committee, or JCP, which had been making recommendations and proposing amendments so that it could be finally tabled in the Parliament. But on Wednesday, the government decided to withdraw the bill, a decision that came as a surprise to a lot of people who had been keeping track of its developments. Though in some ways, the decision has come as a relief to civil society groups that were completely against some of the recommendations that were being made by the Joint Parliamentary Committee. In this episode, we take a comprehensive look at why the recommendations were being criticized, the concerns they raised for individuals, and why the government has now withdrawn the bill. And to talk about it, we are joined by Indian Express's Soumyarendra Barik. And he begins by telling us the origins of this bill and how the need for it was first realized. And he says the conversation around it first started in 2012, which is 5 years before a Supreme Court judgment declared privacy a fundamental right.
So in 2012, actually, when the Planning Commission under the UPA government used to exist, a committee was formed under Justice A.P. Shah, who's the former Chief Justice of the Delhi High Court, by the then existing Planning Commission. And that committee had submitted its report to the government in October 2012. And it had, outlined broad 9 core areas of privacy protection, including how consent should be gathered, purpose limitation. That is, if I'm telling you that I'm collecting this particular data for a certain purpose, I shouldn't exceed that purpose or start using that particular data for other purposes, basically.
These were just some of the basic principles of data privacy. And this was required especially because since the expansion of the internet and wide-scale use of technology, users have been generating a lot of data. And many companies collect and use this data but are not held accountable for taking it without consent or if the data is accidentally leaked. But this conversation was happening in 2012. And then 2 years later, the government changed. And the NDA led by the BJP came to power. Soumyarendra says that the conversation around this subject stopped after that.
We actually started seeing a lot of push that was being made by the new NDA government in 2014, for Aadhaar. Several schemes were being linked, etc. There was a huge push to start onboarding a lot more people on the Aadhaar platform. And that actually saw a number of people start filing petitions, saying that maybe the collection of this Aadhaar data, etc. could breach my privacy and everything. So then the Supreme Court actually formed a 9-judge bench just to look at first that whether privacy to begin with should be a fundamental right or not. And thankfully for all of us, the bench actually ruled that privacy should be a fundamental right and also directed the government then to, formulate a data protection framework for the country.
It was after this decision that a committee was formed, led by Justice B.N. Srikrishna, a retired judge of the Supreme Court. And the purpose of this committee was to give directions to the government so that it could come up with a substantive data protection framework for the country.
Also keeping in mind this, we've reached 2017. So, this is also the time when we are seeing the internet ecosystem having genuinely emerged as a place where economy is thriving, economy in and of itself. So those considerations are also being made, a data protection framework, but also from the perspective of maybe how digital trades, etc. could be facilitated. And in fact, interestingly, the report that was finally prepared by the Sri Krishna committee and submitted to the government, the title of the report was A Free and Fair Trade Economy, Digital Economy. So, that sort of shows you the thinking with which the committee was first of all formed. And of course, the thinking that the committee finally put into making its final report and its recommendations to the government.
Now, before we go any further, let us understand why a data protection law was needed and is still needed. We mentioned earlier that the Supreme Court has declared privacy a fundamental right. But without an actual law, companies can't actually be held accountable if they violate your privacy. It gives them a lot of leeway.
there is no loophole because there is no law. So, at least in India's privacy protection, data protection framework, it really is the wild, wild west, because there is nothing that lays down rules, tells a company how to collect data, how to store that data, how to process it, all while, in each of these steps, preserving people's privacy. So those granular details about how, when a company has collected my data, should be handling that data, those granular details, and, that is where we don't have a law of the land.
This is where the problem lies. And this is the reason why the Justice Sri Krishna Committee was set up. Now, in July 2018, the committee submitted a draft data protection bill to the Ministry of Electronics and IT, which said that it would borrow ideas from it and come up with a new draft bill. This finally happened in 2019. It was then presented in the parliament, and after that, it was decided that this new draft by the ministry should be referred to a joint parliamentary committee.
So that is where, this JCP, the Joint Committee of Parliament, came in, because the understanding was that it would be filled with people, of course, from the ruling Bharatiya Janata Party, but of course also from people from the opposition. So at least the initial idea was that because, it'll go via this bipartisan, so to say, process, maybe there is a chance that, it may not end up serving the purpose or serving for the benefit of a certain entity, or let's say in this case, the government, etc. That was at least the core idea. It went to the JCP, so from 2019, the JCP kept on working, kept on deliberating. It actually held, clause by clause analyses of the draft bill that it had. It got testimonies, from people in the government, from industry, from academia, from people from the civil society. And then it finally came out with this report in November 2021, which was later tabled in Parliament in December 2021, after which it was there. And now this development that, the government has basically moved Parliament to withdraw that report, the JCP's report, from the custody of the parliament, because they want to now present a new draft bill and sort of have a debate on that.
He says that in that sense, we seem to have taken 4 steps back and gone all the way back to when the JCP first started looking at the bill.
And, the consensus and the understanding that we as a collective were starting to develop, about, okay, a data protection framework in the Indian context looks like this. It has these exemptions for the government. This is how a company is supposed to gather consent from a person. This is how they're supposed to store their data, etc. Now all of those things are again up in the air.
But now the thing to note is that the Joint Parliamentary Committee had proposed 81 amendments to the bill that was finalized by the Justice Sri Krishna panel. And it also made 12 recommendations that ended up changing the very mandate of the bill. These amendments and recommendations were criticized not only by privacy rights activists, but also by giant tech companies like Google and Facebook.
So essentially what happened is that the general feeling after the JCP's report became public was that the JCP took a bad bill and made it worse. In that some of the provisions that were already criticized before, the bill went to the JPC, when the final version came out, and that's when we thought, right, because of this bipartisan discussion that was supposed to happen in the JCP's meetings, etc., that flavor was not really visible in the final version of the bill that was tabled in the parliament. There were 2 very problematic clauses going in to the JCP. And I think when it came out from the JCP's clutches, we saw that, of course, those 2 were retained, if not made worse. But then there were several new ideas that were floated in the shape of recommendations that, okay, maybe you should also deal with this. Maybe you should also deal with something else that you already are not dealing with. So in particular, I'll start off with the 2 most problematic ones. So the first one, which tech companies specifically, the big tech companies like Facebook and Google, they were really unhappy about, is this thing called data localization.
For those who may not be familiar with the term, data localization broadly means storing the data of citizens or residents inside their country. Now, to understand what issue tech firms had with this, Soumyarendra explains how the bill defined personal data, which is essentially the data through which you can recognize an individual.
The bill categorizes personal data into 3 categories. One is your personal data. One is sensitive personal data, which includes data like financial data, health data, biometric data, etc. And the third thing is called critical personal data. Now, the problem first there is that even though we have some broad understanding about what sensitive personal data is, critical personal data was not defined in the bill. That was supposed to be defined by the government from time to time or at a later stage. Now, the bill said that for the sensitive personal data category, that particular data could have been transferred from India to other countries, but still a copy of it had to be stored within the boundaries of India. And this critical personal data, which was not defined, the bill said that this critical personal data has to remain in India. It cannot be sent outside.
So data localization for both sensitive and critical personal data, which, like mentioned before, the bill did not define.
Now, there were aversions about it. There were concerns that, okay, what if critical personal data and the definition of it later, whenever it happens, there is a high potential that the definition could become a very political one. What is critical personal data? What you cannot take out? What you mandatorily have to store in India? And, the biggest thing about data localization, at least from a government perspective, I'll come to the tech company's perspective, but from the government's perspective is of access, right? If your data is sitting somewhere in Europe where, you have a privacy framework like the General Data Protection Rules, the GDPR, which is, one of the most progressive and one of the most stringent, actually, privacy protection frameworks of anywhere in the world. Even though you might think that this is an Indian's data which is not living in India but in Europe, ironically, that data is actually more safe in Europe simply because it's under the jurisdiction of a region where privacy is valued, where there are very serious and strong laws for protecting people's privacy, even if that person is not an Indian himself, herself, or themselves.
This essentially means that, say, if the government requires access to your data, it can do so much more easily if it is being stored in India than if it is being stored in Europe, because of the strong European data protection laws.
So from the government's perspective, the idea was about access, they wanted immediate access to Indians' data for that matter. But for tech companies, the problem was a little different. They argue that we live in a very global economy, right? Where your infrastructure lies doesn't really matter. My services, even though my servers, my entire headquarters, all of my employees could be in Europe, but my services will work unhindered and just as well in India, despite me not really having a physical presence in the country. That's just the nature of the internet and the beauty of the internet, right? Now, for them to start localization, they would have to had set up this entire infrastructure here. Now, the government also said that, okay, if you're setting up servers here, that will end up generating a lot of employment. That was also an angle that was put forth. But of course, they were very quick to shoot it down, the tech company, saying a server actually doesn't really employ. Of course, it takes a lot of land and everything, but it doesn't really employ a lot of people. You don't really need a lot of people to run a server, just storing your data and doing nothing else. So tech companies were actually very, very upset about data localization. Many companies have actually come forward and, made their objections very public.
And he says that this is not very common. Global tech companies don't usually disagree with governments this openly.
Recently, in an interaction with Indian Express, Google's chief privacy officer, Keith Enright, said that, data localization norms should ideally be as narrowly tailored as possible. And of course, there was an acknowledgement that it might serve a legitimate law enforcement requirement, but that is very, very limited. And then to bring out a very broad, a very overarching localization mandate would really hurt their business and just how, they do their services. So localization perhaps had the biggest pushback from the industry side.
He says that for them, this is an added cost that they do not want to bear. But besides data localization, the other major thing that was criticized was Clause 35 of the bill. This clause gave blanket exemption to the central government and any agency that it chose to notify.
So, for instance, tomorrow, if the UIDAI, which issues our Aadhaar cards, etc., the government was well within its rights to say that the UIDAI will be exempt from, the data protection bill, despite dealing with the personal data of 1.3 billion almost Indians, right? So that would have created a regime, or that can still actually, we don't know if it's going to be there or not. That might create a regime where, the government has unbridled access to your data at its beck and call. And now when you club that with localization, the concerns around surveillance, there are two things, right? If your data is being gathered and not being kept safely, that is a violation of privacy. That is a framework you'll call that, okay, this is not a very privacy protecting framework. But if your data has been gathered without your consent, without you knowing, etc., that in a way is surveillance, right? You don't know who has taken what about you and knows what about you and how that might be used against you at some point in your life.
This is the reason why he says that this was seen as a very political move. And opposition members in the JCP spoke against it openly. Now, from the government side, this was being pegged as a national security issue.
That's actually how the JCP's report starts. The preamble itself mentions, the nation's security and everything, which people were questioning that you are dealing with a data protection framework. And why is national security taking precedence in every single legislation that you're bringing out? No one is negating the fact that, of course, the security of the nation is very important, but does every legislation have to prioritize national security over the actual thing that's actually going to solve? And of course, you have to remember when the JCP was also finalizing its report and doing this clause by clause analysis, it listened to several government ministries, MeitY, Home Affairs, External Affairs, etc. And, these government testimonies, one would assume, are very, very influential in the final decision-making process. And that, of course, finally came through. So, all in all, the biggest two things, data localization, bad for business, as business said, and Clause 35, which basically allowed blanket exemptions for the government and its agencies, which people said could lead to a massive surveillance regime.
In fact, he points out that when Justice Sri Krishna saw the bill that came out of the JCP, he said that the bill is going to create an Orwellian state, meaning a totalitarian state.
And that's one of the things that people are saying, they are actually in many ways relieved, saying that the initial idea of the bill to what it finally became, the bill was nowhere recognizable to what it actually set out to do. It became something else. It started dealing with non-personal data. It started dealing with national security. And people all the while are wondering, why are you talking about these things in a personal data protection bill? By the way, the name of the bill, when it went to the JCP, was Personal Data Protection Bill. But when it came out, it became Data Protection Bill because non-personal data was also included in it. So yeah, a lot of things happened there.
And now we come to the reason why the government has withdrawn this bill, or at least why it says it has. Some officials told Soumyarendra that because the JCP had suggested so many amendments, the ministry would have to redraw the contours of the legislation. The government has also said that it will look at creating a comprehensive legal framework to regulate the online space, which will include bringing in separate laws on data privacy, the overall internet ecosystem, cybersecurity, telecom regulations, and harnessing non-personal data to boost innovation in the country.
So that is what the government is saying. And of course, there is an acknowledgement from their side. And we'd reported on this earlier that several startups had written to them, complained that, several of the provisions within the data protection bill, the draft one, were very, very quote unquote compliance intensive for them. And they would rather be okay with a simpler act where it's easy to comply even while it protects privacy. So that is largely the line that the government is taking.
But this reasoning, he says, is also concerning because this in a way negates the entire purpose behind why we need a data protection framework.
And the classic analogy that I would like to draw here is from the automotive sector, right? There was a time in India where we had cars, but none of those cars had airbags, right? So from that time onwards to the government mandating one airbag on the driver's side, then to two, now there's conversation of increasing airbags mandatorily to even a higher number. All through this process, there was massive pushback from car makers, etc., because their costs were going up. But you also have to see what you're solving for, right? The other side of it is equally important. Sure, maybe you don't want to trouble an entity like a startup in the country. I respect that. But what is the cost of that, right? What are you losing out because of it? You're losing out for if that startup goes rogue or if that startup does not have hygienic privacy practices, whatever, that startup could just have 100 users, right? The privacy of those 100 people is not protected, in which case at least 100 citizens in India would not be enjoying their fundamental right of privacy.
He also says that relaxing data privacy norms so that startups can comply with them easily can also lead to problems that we have already faced with companies like Uber, which were startups at one point but have now bypassed regulators, exploited loopholes, and put pressure on governments to rewrite laws in their favor. This is what the international investigation called Uber Files had revealed.
Now, the argument that a startup needs or should have some sort of leeway, I feel you have enough examples today to know that, okay, that maybe is not the right way to proceed further. And the government takes objections, big tech companies. They say that Facebook already collects so much of your data. Google already collects so much of your data. I think the flip side of the argument is that there was a point in time several years ago when Facebook, Google, Twitter, etc., they were startups themselves, right? They could come ahead. They did what they did because they were living in a world where maybe privacy laws weren't as strong. Maybe if we were having the discussion of a data protection regime back in 2000, of course, it was impossible to have it then. But, for instance, if we were, maybe we wouldn't have seen such huge conglomerates come out whose entire business is driven by your and mine data, targeting ads, cross-selling products, etc. that the online advertising ecosystem grew up because there was rampant tracking of users, profiling of users, serving them targeted ads, etc. So that is a thinking that maybe needs to come out, which isn't. And I feel that's a bit problematic.
Meanwhile, the sources in the ministry tell Soumyarendra that the government is targeting the winter session of the parliament to introduce the new legislation. And we'll have to wait and see what the new bill will and will not include. But for now, there does seem to be an understanding that some of the recommendations, like those regarding data localization, don't really fit in the data protection bill.
So the understanding, I think, is that these things will definitely be dropped from the data protection bill, but they will be retained in the larger Information Technology Act revamp, which internally they're calling the Digital India Act right now. At least from the sources that I've gathered is that these things will find, sort of a reflection there. Now, specific vis-a-vis to data localization and cross-border data flows, I think the government is looking, or at least discussing right now, to dilute some of those norms and basically go via that quote-unquote trusted geographies path, which is a path we've seen before as well, right? Like, as the Indian government, I recognize that a certain region, I consider it to be safe, and a certain region, I don't really consider it to be safe. So of all the regions that I think are okay, and if your data is stored there, it's okay. Then I wouldn't mandate localization. But even there, the caveat is that if I am investigating a crime as an Indian law enforcement agent, my access to that data should be unhindered. So irrespective of where the data is, in the event of a crime, I need to have that data.
He says that if you talk to civil society groups, one thing they continue to advocate is that the clause 35, which gave blanket exemptions to the government, should be dropped. And the other thing they talk about is the larger surveillance reform in the country.
Now, surveillance largely is not under the purview of the IT ministry, surprisingly. It's under the purview of the DOT, and it is actually largely done by the Telegraph Act, which, is the core telecom regulation we have in the country. So there has been a lot of demand to, overhaul the surveillance regime in the country and, come out of the era of just phone tappings, because surveillance today is multifaceted. We've seen incidents like Pegasus, etc., where in some cases you don't even have to click on anything in your phone. Just by opening something, or like even opening a basic message, your phone can somehow be infiltrated by a certain kind of a virus and its data be compromised. So surveillance and the meaning of it today, both from government, state actors and, non-state actors, has significantly changed. And there genuinely is a big need to bring out this surveillance reform. But the unfortunate thing is that for there to be an overall in surveillance reform, there also has to be an acknowledgement of surveillance in the first place, which is missing. The government will not say that we surveil people, right? They will say that we collect data for delivering services, for instance, or because there was a pandemic, or because there might be health emergencies, etc. So there are ways that the government can still protect itself, of course, because it makes its own rules. But yeah, so I think privacy advocates will largely, or have largely said, that at least the exemptions to the government should be under check.
He points out that no one is saying that exemptions should not be given to the government. In fact, even in the Supreme Court judgment, reasonable restrictions were placed on the right to privacy, and a 3-pronged test was prescribed for it.
First of all is legality, second is legitimacy, and third is proportionality. Legality, of course, there has to be a basic law, which is very clear. Legitimacy or necessity, is this necessary to do? That thinking has to come in. And the most important one is proportionality, which is where a lot of the debate right now is happening vis-a-vis privacy, right? For instance, if the government will say that I want to know who the originator of the first message is on WhatsApp, and WhatsApp will come back and say that this is disproportionate, because to do this, basically, we will have to dilute our entire encryption security, which basically is that is the existence and that is the gap that my platform fills. That is my sort of business advantage over the others, etc. And then there are these conversations, for instance, that what happens, for instance, when in India, because you have certain rules, and because WhatsApp, if it has to sort of operate here as quote unquote an intermediary, it will have to kind of adhere to this. What happens in a case that because it wants to do this in India but not elsewhere, that you have a different WhatsApp for India and a different WhatsApp globally, right? I mean, I personally would be very upset to know that my peers in the United States of America or in the European Union are using a WhatsApp which is a bit more safer privacy-wise, and there is perhaps little room for kind of backdoor access, etc. compared to mine. I mean, I, as an individual of the country in India, I would be like, why is my country doing this? So yeah, these are discussions that need to be had, and activists, privacy advocates, and the society will say that even though there might be a need for exemption for the government, that has to be within the limits of this 3-pronged test that was suggested in the right to privacy judgment. which has not happened so far, right?
You were listening to Three Things by the Indian Express. Today's show was written and produced by me, Shashank Bhargava, and was edited and mixed by Suresh Pawar. If you like the show, then do subscribe to us wherever you get your podcasts. You can also recommend the show to someone you think will like it, share it with a friend or someone in your family. It's the best way for people to get to know about us. You can tweet us at Express Podcasts and write to us at podcasts@indianexpress.com.